Welcome back. Today, the U.S. Supreme Court will consider the Indian Child Welfare Act. It could change how Native American children are placed in homes and how they are adopted. Our 9 News legal analyst, Whitney Traylor, joins us to break down the case. So what is the history behind all this?
Yeah, it's really interesting because this basically from the late 1800s into the mid 20th century, there were these adoption. They were taking the Indian children off from their tribal families, and it was an assimilation process. And this was both private and public. And they had quotes like, "Kill the Indian in him and save the man."
Oh, boy.
And they were trying to take them from their savage parents and these kind of things. And so they really tried to take away the culture. So there was no language, any of that, the names, that kind of thing were all changed. And so these boarding schools, Congress realized what was happening, and there was so much studies and everything else that in 1978, Congress passed the Indian Child Welfare Act, known as ICWA. And ICWA is basically saying that if there's a child being adopted from the tribe, they first must go to a family member. If there's not a family member, another tribal member, so that they essentially stay within the Indian culture, because it was being erased. There were 83% of the kids were in these boarding schools that were erasing the culture. So it was to undo that. That's what's now at issue in front of the Supreme Court. A white family is now trying to adopt Native children, and they're challenging this law.
Yeah, and some of those schools were in Colorado, in fact. So what is the legal case? What's the court going to decide?
Right. So the court is looking at whether the ICWA, whether it violates the Equal Protection Clause based on race. There's also an argument between the state and the federal government. So Texas is actually a plaintiff saying, "Hey, feds, you can't come in and tell us what to do." And the feds are saying, "Well, yes, we can under this statute and under the Interstate Commerce Clause and other things." So it's a real battle between, one, whether they're making this distinction based on race under the 14th Amendment, which they're saying would be a violation. The Biden administration is responding and saying, "No, we're not basing this on race. We're basing it on tribal association," and they're almost treating it as a sovereign, a political subdivision, a sovereign nation, if you will. And so that's the issue, and whether or not the federal government can do it, or whether the states get to do this.
And you say that this is a big case because it could, in the long run, affect other cases.
Absolutely. This is a very big case because it's looking at equal protection and the way we analyze race cases. And so since race is coming up in so many other instances, you're going to see this be relevant. And then as it relates to the Native Americans in terms of the treaties and all the other things that are in place, because this takes away power from the tribal courts and says that, yes, if they deem this act unconstitutional, then that really weakens the power of the tribal nation.
That is really interesting. Yeah. So any idea how it's going to go?
Well, it's interesting. I mean, we have a 6-3 conservative court that would seem to lean towards ruling it unconstitutional, but Justice Gorsuch has, on all these Indian cases, has ruled with the liberals, which would still make it 5-4. So I suspect it would be deemed unconstitutional, but a number of states are already enacting this protection into their state law, just like they did with Roe.
With abortion,
Yep.
All right. Whitney, always good to see you.
Sure.
Thank you.
All right, good to be here.